Good evening, everyone, and welcome to BicTok, our 39th session, titled Review. Titles will be in relation to sports arbitration. So, with the rise of esports and the increasing complexity of sports dispute, so we think that this topic is more relevant than ever. So, give an introduction. My name is Michelle, and I'll be your host for today's session. And before we begin, let me run through a few housekeeping matters. So firstly, kindly ensure that your Zoom username reflects the name under which you register, and this will allow us to accurately mark your attendance and, where applicable, issue your certificate of participation as well as for your CPD points. Secondly, if you have any questions throughout the session, please feel free to leave them in the chat box. Alternatively, you may also raise your questions uh, during the Q&A session at the end. Now, we are privileged to have Professor Samrith Kaur as our moderator, and she is the managing partner of Samrith Sanjeev and Partners and heads the firm's dispute resolution division. And she sits as an arbitrator, mediator, and adjudicator on numerous international and regional panels and has served in major sporting events such as the 29th SEA Games in Kuala Lumpur in 2017. And we are truly privileged to have her moderating today's session. And I will now pass the floor to Professor Samrith to guide us through today's session. Professor Samrith, the floor is yours.
Thank you very much, Michelle. Good morning, good afternoon, good evening, and welcome everyone, wherever you may be logging from. On behalf of BICAM and the Sports Law Association Malaysia, I would like to warmly welcome all of you, the participants today, to this webinar entitled Resolving Sports-Related Dispute, The Way Forward. Thank you all for making time for this. I must also extend my sincere appreciation to our distinguished panelists for taking out their time, very busy schedules they have, and gracefully agreeing to participate and share their insight with us today. We are truly honored to have such an experienced and accomplished panel, and we look forward to an engaging and insightful discussion. Before we begin, let me just briefly introduce each of our panelists. As you know that by they don't need much of introduction. Dato' M. Rajasekaran, he's a senior Malaysian lawyer with over 4 decades of experience in dispute resolution and arbitration. Called to the Bar of England and Wales in 1983 and admitted as advocate and solicitor of the High Court of Malaya in 1984. He has also appeared before federal court following ad hoc admission to the High Court of Sabah and Sarawak. He holds a certificate of advanced studies in international sports law from University of Zurich. A leading figure in sports dispute resolution in Southeast Asia, Dato' Raja chaired and pioneered ad hoc arbitration panel for the 29th SEA Games Kuala Lumpur in 2017 and was reappointed for the 32nd SEA Games in 2023 in Phnom Penh and 33rd SEA Games in Bangkok. He currently serves on Malaysian Sports Dispute Committee and sits on International Sports Integrity and Disciplinary panels. Now, Paul Hayes, King Counsel, also is a well-known figure. He's a member of 39 execs chambers in London and Singapore and practices primarily in international commercial arbitration, commercial litigation, sports law, and other related areas. He has appeared in complex commercial disputes, defamation trials, sporting cases across multiple courts and arbitral forums worldwide, including numerous landmark matters before the Court of Arbitration for Sports over the past 2 decades. He sits on the arbitration panel of SIAC, AIAC, and ACICA. He's a widely published author in arbitration and sports law, and is the founder and editor of Australian and New Zealand Sports Law Journal. Paul serves on the World Rugby Anti-Doping Judiciary Panel and has held judicial roles with several international bodies. A former elite athlete, he has competed internationally in rugby unions, bobsledge, and rowing. Now, Thomas, who also needs very little introduction, is a Deputy Director of Legal and Governance for Badminton World Federation, BWF, based in Kuala Lumpur, where his practice focuses on sports governance and integrity. Prior to joining BWF, Thomas was Manager of Legal Affairs for the World Anti-Doping Agency, and he since continued to be involved in sports integrity, acting as arbitrator, auditor, trainer, and consultants for various organizations. Thomas is a member of the Bar of Quebec, Canada, since 2010. Having graduated from University of Sherbrooke and subsequently obtained an MBA from INSEAD in Singapore. Thank you, Dato, Paul, and Thomas for agreeing to take part in this discussion. Now, we will start, and I'll start with saying that we have seen and heard sports today is no longer just about competition on the field. It is a complex ecosystem involving governance, commercial interests, athlete welfare, media scrutiny, and public trusts. And inevitably, disputes arises, and how we resolve them says a great deal about how integrity of sports itself is. So this session will explore what are sports disputes, how sports disputes are currently resolved, where the pressure points are, but most importantly, what future should we look, what this future should look like. We will discuss governance, athlete rights, arbitration, mediation, and emerging challenges that are reshaping the landscape. Now, to start off with, Dato' Raja, you recently served as a chairman of the ad hoc arbitration panel for the 33rd SEA Games, a regional multi-sports event sanctioned by Southeast Asia Games Federation. For those unfamiliar with the mechanism, what is an ad hoc sports arbitration panel? Why is it necessary during major multi-sports events, and how does it differ from ordinary arbitration proceedings?
Yes. Thank you, Samrit. Your first question, what is an ad hoc sports arbitration panel? Ad hoc, by definition, means something created for a specific temporary purpose. Short-term, formed for a single event. The Southeast Asian Games, or SEA Games, as is commonly known, is such an event. The Charter of the Southeast Asian Games Federation provides for the establishment of an ad hoc arbitration panel to resolve disputes in an expedited time frame. It is a temporary tribunal constituted specifically for the duration of the Games. Arbitrators are appointed in advance so that any dispute arising during the competition can be heard and determined immediately. Disputes can arise in real time and may directly affect an athlete's participation. It may affect medal outcomes, and also a country's standing. In such a setting, disputes cannot be resolved after the event without undermining the integrity of the competition. So, unlike an ordinary arbitration, ad hoc sports arbitration operates on a highly accelerated timeframes with simplified procedures and very short decision timelines. We have what is known as a very compressed procedure. Sometimes decisions ought to be made within 24 hours. The objective is not only legal correctness, but also ensuring that the games proceed smoothly and fairly without disruption, tailored for immediate results, without compromising the integrity of the games. That's what it is. I can't hear you. We can't hear you, Samrit.
Sorry. Thank you, Dato'.
Yeah.
Thomas, turning now to the governance and decision-making structures within International Federation, IF. We know that the International Federation plays multiple roles, including regulators, rule makers, and often dispute resolvers. This concentration of function naturally brings into focus questions of independence and impartiality. With that in mind, how do the International Federation ensure independence and perceived fairness when decision makers are appointed within the federation structure?
Thank you, Samrit, for your question. And maybe I will also clarify, because yes, we are rule makers. We make our own ethics regulations. Yes, we have disciplinary panels, but in between those, we're also the investigators. We are the police, so to say. So naturally, it would pose a problem if, on one hand, we were investigating a case, and then following that step, we would have individuals who are closely related to us who would then be deciding on the case. We would be police and we would be jury. So it's actually interesting to see how the BIF tackled this issue. If we go back to 10 years ago, our disciplinary panels had as arbitrators our council members. So obviously they had a conflict of interest. They did to the best of their ability not to be impartial, but we are all humans. So sometimes it was a bit tricky for them. Then we had a big evolution. The BF started appointing arbitrators that were independent from the organization. It was a very good step forward, but with some limitations, because we were still appointing directly the arbitrators. So there was perhaps a perception of partiality from these arbitrators. And a few years ago, we reached our current stage where we have an appointment body that's independent from our organization who is appointing these arbitrators. And our goal is to limit any potential perception of partiality that our arbitrators may have towards our organization. So usually we try to go to support that independence, to limit any kind of perception that could exist between us and our decision makers.
Interesting, thank you. Now, Paul, to bring an external adjudicatory lens, from your experience as CAS arbitrator, are there particular features of CAS proceedings that help mitigate concerns athletes may have about the structural or perceived bias at the federal level? And if continue, the second question would be, what are the key safeguards then or practices that most effectively reinforce confidence in the neutrality of the decision-making process?
Thanks, Samrit. And thank you very much to you and to Bikram for your kind invitation to participate this evening. So, and a big hello to all of the Bikram members this evening. Thank you for joining us. In respect of your question, firstly, I do need to correct one small flaw in the question. I'm not a CAS arbitrator. While I'm on the main panel at SIAC and also on other arbitral panels, at CAS I deliberately choose not to be an arbitrator or apply to be an arbitrator, because in CAS, and this really feeds into your question, it has a rule where if you are a CAS arbitrator, you cannot appear as counsel before CAS for the duration of your term while you are a CAS arbitrator on your 4-year term. Now, that's, I think, a really good safeguard to ensure the perception of independence as much as it is in real terms to ensure independence. The last thing, the sports law world is a very small club, if you like. Everyone tends to know each other. And you certainly see that to a large degree in CAS. It's often, you look at CAS awards, it's despite the fact that there are 400 arbitrators on a closed list panel, you still have probably the same 50 or 60 arbitrators who are consistently writing the awards. The same with counsel. In different parts of the world, it's always the same 2 or 3 people who are turning up to argue these cases. So everyone tends to know everyone, and I think that familiarity can erroneously, and I emphasize that because if you're an outsider, there can be a perception this is all, everyone knows each other and this is all a little bit of a club. And so I think that's a really good move on the part of CAS, that if you are on the panel, then you can't appear as counsel before the panel or the duration of your term as a member of the panel. So that's, I think, a particularly good feature. The second thing about CAS, in terms of dealing with concerns by athletes of bias is perceived bias is not a ground for review. You have to show actual bias, as we know, in terms of challenging an award, because ultimately with the Court of Arbitration for Sport, it's really important to emphasise that it's not a court. It doesn't have its roots in the soil of the state, whether it be through the inherent jurisdiction of a court or alternatively by way of statute. It's an arbitral tribunal. It's no different to SEAC, the AIAC, the LCIA. It just happens to be in Switzerland and specialise in sport. So it's no different to any other international arbitral tribunal. And it's really important to remind ourselves with CAS that it doesn't exist in accordance with some multilateral treaty or anything of that nature where we all got together like it did in respect of the International Convention Against Doping on Sport and said, oh, we also want to have an international treaty where states all signed up to say we'll agree to this international tribunal to deal with sporting disputes. No, that didn't happen. What happened was it was set up, to essentially conform with the 1958 New York Convention. So it has its roots really in commercial arbitration, which when you consider that all sporting disputes are contractual by nature, they start off with a contract. That would seem to have been in what is now the 42nd year of CAS's operation, having been founded in 1984. That would seem to sit very neatly with the commercial arbitration model. So because it's a commercial arbitration tribunal, it attracts a lot of commercial arbitration practitioners who also happen to have an interest in sport. And these are people from all around the world, and they're appointed by the International Council of Arbitration for Sport, which is an independent body which came into being about 25, 30 years ago, after the case of Gundel. In fact, it was after the case of Lazatina and Danilova challenging the Swiss Federal Tribunal to ensure the independence of CAS. And that independence is taken very seriously by ICAS, its overseeing body, which is separate to CAS, not only to ensure that it exists in terms of its funding, but also that those who are appointed to the CAS panel are very experienced international arbitrators with experience in sport and are of the highest integrity. So in that sense, the very structural foundation of CAS, and also given the fact that if you have a CAS appeal under the CAS rules, the appealing party gets to choose or nominate its arbitrator. The respondent to the appeal gets to nominate its arbitrator, and then CAS will appoint chair of the panel. So those processes go a long way to overcoming any perception of bias. In other words, the independence of CAS is structurally well-rooted by those types of procedures. And of course, if you have concerns about an arbitrator, you have the same rights as you would for any commercial arbitration under all of the different state legislation that have implemented the New York Convention. You can make an application to remove an arbitrator on grounds, and there is that provision also within the CAS rules. So in a situation where athletes are very much the minnow in a sporting dispute, and the deck does seem to be loaded against athletes because you have a lot of pretty heavy regulation that place quite an onerous burden on the person who participates in elite sport at the highest level. A really good example of that is the athlete's whereabouts regulations under the World Anti-Doping Code, where I'm not too sure of any other form of endeavour where you have to report in and identify where you're going to be in a 2-hour window every 24 hours, every day of the year, so that doping testers can find you. That's a pretty big imposition on your life. But if you're playing sport at the highest level, it's obviously a price everyone is prepared to pay. So in that system where the deck is loaded against the athlete, the structural safeguards that I've articulated just before, I think go a long way to reassuring the independence of CAS which also ensures and has arbitrators to ensure the athlete that you're going to get a fair and a safe hearing. And that's the sort of challenge I think that'll face regional sports arbitral tribunals in the years ahead, getting outsiders, not from those who are inside sport. This is part of the thinking between myself, Tunku Imran, and Datuk Sundaraju when we, many years ago now, thought about establishing the Asian Sports Tribunal and setting that up. Thinking was to take these disputes away from the ad hoc domestic tribunals of the individual sports and put it in a central body where you have people from not inside the sport coming in to determine those sporting disputes. And so in that sense, I think Malaysia is pretty much, it's a good model. If that model is going to continue to be pursued in Malaysia and it's not departed from, then for regional arbitral tribunals, that's a good model to follow.
Yeah, we should relook into that again. Okay, moving on. Thank you, Paul, for the explanation. Dato' Raja, stepping back, sports dispute today go far beyond disciplinary matters. Could you explain what constitutes a sporting dispute, how such disputes are typically resolved in Malaysia, and the key challenges in this area?
Yes, sports-related dispute is one that arises of what is often referred to as the sports contract between the athlete and the relevant sports organization. These disputes commonly involve selection, eligibility, disciplinary sanctions, anti-doping, can be governance issues, sponsorships, commercial matters, and increasingly athlete welfare and even safe sport concerns. In Malaysia, disputes are generally resolved through a tiered framework. The first level is the internal dispute resolution mechanism of the sports body itself. And the principle there is one need to exhaust your domestic remedies. If the matter cannot be resolved internally, it may be referred to the Statutory Sports Dispute Committee under the Sports Development Act of 1997. In appropriate cases, disputes may also be resolved through arbitration, either domestically or internationally, with recourse to the courts being the last resort. The key challenge to my mind is that time is often critical in sport. Delays or procedural uncertainty can effectively end an athlete's career or compromise the credibility of a competition, which is why specialized and efficient dispute resolution mechanisms are essential.
Thank you, Dato'. Thomas, if I can ask you this, from an international federation standpoint, what are the most common categories of sports-related disputes you see in your practice today?
This is actually a very interesting question because the question I get the most from people, from lawyers or otherwise who are not involved in sports is, what do you actually do as a sports lawyer? So Dato' Raja has given a good overview of the different types of dispute that we have. They often involve athletes, but actually not only. But I would say that they comprise the majority of our caseload. So in our case, there's a lot of integrity-related matters. And by that, I mean anti-doping, anti-match fixing, safeguarding. Probably for us, match fixing or the fight against match fixing is what takes the bulk of our time. If you were in other sports than badminton, perhaps weightlifting, not to target anyone, perhaps anti-doping would be their biggest source of cases. Beyond that, we have other matters such as ethics. We have officials at world level, at continental level, at national level, and we want to make sure that they act in accordance with our code of ethics, with our code of conduct. Perhaps something a bit more special or specific that we have is in relation to our para-badminton program. So in para-badminton, we have classification. Classification means that you have athletes who have different kinds of impairments. We must put them in different sport classes in accordance with these impairments. And that leads to a lot of disputes. Some athletes may want to be considered in a special sport class, but they were classified to be in a different one, and that can lead to protests, that can lead to appeals that tend to be very technical. So that has been keeping me busy lately. And finally, in relation to governance, we have disputes between our members. We have disputes between office holders of our members who each will claim the leadership of the federation, which can be quite tricky because you have national law applying, you have 2 points of view, usually based on domestic law. And I'm not familiar with the laws from all countries in the world, so that can be quite tricky. And finally, we have a vetting program that will lead to its own peculiar problems. So basically, we carry out a due diligence process on our officials, and that raises its own sets of questions when usually things will be smooth, but when there's an obstacle, usually that will be a big obstacle in the road. So it's quite diverse, and I think that's the interesting part about practicing in sports law.
Yeah, that is interesting. Yeah, quite a lot there. Paul, if I can, move on to ask you, once a decision is rendered in sports dispute, what challenges commonly arises in the terms of enforcement or compliance, and how are these typically addressed?
The general response is an appeal to CAS. So that's the starting point. We're dealing with an appeal from a decision first instance of CAS or of a regional sports tribunal concerning an international level athlete or an issue that's involved in the World Anti-Doping Code. So anything to do with the Olympics, anything to do with WADA, ultimately you have to preserve a right of appeal to CAS from a decision at first instance. Further, with a lot of international athletes in terms of conduct under many dispute procedures of many IFs and NFs, again, for the higher level athletes, voluntarily, a contractual provision appears in those directives that gives international athletes a right of appeal, CAS. So starting with CAS and dealing with these awards you're dealing with high level athletes, starting with those athletes. What you have in terms of enforcing the award is, in theory, you have the machinery, because CAS is seated in Switzerland, in the canton of Vaud, of which Lausanne is the principal city. You have the machinery of Swiss Federal Code on private international law, and under PILA, as it's referred to, the Private International Law Act in Switzerland, no different to the Arbitration Act in Malaysia. You have all of the common grounds on which you can challenge an award, if you're going to challenge the enforcement of an award, that are apparent under Articles 4 and 5 of the New York Convention. And under PILA, they appear in Article 190, subsection 2 of the Public International Law Act. So, unfortunately for international athletes, you have to take your chances. You're going to challenge the award. You have to take your chances in Switzerland, in the Swiss Federal Tribunal. Having said that, more and more CAS awards are being challenged in the Swiss Federal Tribunal. And the grounds of challenge, there's no merits review here. It's just purely the grounds, the usual grounds upon which you'll challenge an international arbitral award. In other words, the arbitrator didn't decide all that was submitted to the panel for arbitration, or went beyond the bounds of their remit, or they didn't give equal treatment to the parties, all the usual grounds upon which you can review an arbitral award. So in theory, that's how it can be challenged. In practice, it doesn't get challenged terribly often. So let's assume that an athlete was to try and say, well, look, I'm not going to go to Lausanne and challenge it. I'm just going to keep playing sport. And I'm just going to keep doing what I want to do. And I'm going to ignore the award, and I'll leave it to WADA, say, who might have been the successful party, to try and enforce the award against me in Malaysia. Well, in reality, that's probably not going to happen, because because of the structure of international sports, given the way in which you have national federations which are all affiliated with an international federation. And Thomas will might be able to add something on this, but what you have is you have all of the IFs wanting to be part of the Olympic program and obviously wanting to be part of the CAS, which is ultimately controlled by, even though you do have the International Council for the Arbitration of Sport, that body itself is ultimately controlled by the IOC. Likewise with WADA, when you look at how WADA is set up. So generally speaking, the IF and the NF will take their own steps to ensure that that person who's the subject of an award who might have been banned never gets to see the light of day or play sport, because obviously if they did, they were complicit in that. That would reflect poorly on the NF and the governance of the NF, and you'd probably find there'd be a new national president if it happened at a national level. Happened at an international level, then the nuclear option might be that if it was badminton, for instance, no more badminton in the Olympic program, which would be horrible. So because the IOC seems to have a monopoly over most sports and what I call the sporting oligopoly, the issue of enforcement never becomes, in practical terms, a problem. The awards are generally recognised and most athletes don't have the means to challenge these awards. Now, in terms of any shortcomings on that front and safeguards and the like to achieve fairness, one of the biggest problems in sports arbitration is equality of arms. Now, that's a very different thing to what an arbitrator is supposed to do, and that's afford equal treatment to parties in the conduct of the arbitration. But in many instances, you'll have a very well-funded national federation taking disciplinary action. It might be for misconduct, for instance. It might be somebody who's been somewhat badly behaved in their use of social media, which might have brought sport or themselves into disrepute and might have reflected poorly on the association, which obviously tries to raise money to fund athlete pathways and the like. So an athlete might be dealt with on misconduct grounds. And a lot of the time, it might be a very well-funded and wealthy national federation. Most athletes, because they're not working, and most sports don't deliver large amounts of money in the way in which Lindsay Vonn at the Winter Olympics and others might be raking in. Not everyone's a global superstar. The reality is most Olympians make a huge financial sacrifice to participate in their sport, and very different to professional football or the global stars. So what you do have a lot of the time is a body of regulation, as I said before, which can operate very harshly against the athlete. And then that regulation is enforced by a much better funded organisation against a poor athlete. Now, you can also have the flip side of that. You can have a very wealthy athlete who might be a global superstar in a small country with a small national federation, or a really good example of that. And it didn't quite work out well for Lance Armstrong, but there was, you would think of a doping dispute between the UCI, which is the International Federation for Cycling, and Lance Armstrong. In a doping case, you'd think that the UCI would be as well funded or very well funded, would be the stronger financial party any time, except if it had to enforce its doping policy against Lance Armstrong, who was a multi-millionaire at the time that this all happened. So if you have a particularly wealthy global superstar athlete and you're a relatively smaller sport, a really good example of that might be swimming. Michael Phelps, if he was swimming, all of that talent happened to be for a company or a country that might not be as wealthy as the United States. And so let's just say Michael Phelps swam for, I don't know, Denmark. And Michael Phelps more or less took it on, and we're just speaking hypothetically, took it upon himself to say whatever he wanted to say on social media. It'd be very hard for a small country of 5 million people and in a cold climate where most of them don't swim to take action in a way against a global superstar like Michael Phelps. So the inequality of arms, it's not always the federation against the athlete. Sometimes it's the other way around. That to me, and the way in which the regulation operates And then in terms of challenging enforcement, in most of the cases, if it involves elite athletes, you'll have to go to CAS, or if it's a domestic arbitration, go to your local Supreme Court. Most people just don't have the money to be able to do it. So as a model, that doesn't necessarily operate fairly in terms of ensuring that the party is on equal ground to ensure that their rights are properly reviewed and upheld.
Thanks, Paul, for the very detailed explanation. Dato', if I may move on to you. Internationally, the Court of Arbitration for Sports, or CAS, is often described as the Supreme Court of Sports. Now, for those who may not be familiar with CAS, could you please explain what CAS is and why it was created and why it plays such a central role in resolving sports disputes globally?
Thanks, Samrit. I think Paul has touched on this, and I'll just add on what he has mentioned earlier. The Court of Arbitration for Sports, in short, is known as CAS, is an independent international arbitral institution established in 1984 and seated in Lausanne, Switzerland. It was created specifically to resolve disputes arising in sport, particularly those with an international dimension. CAS resolves sports-related disputes through arbitration and mediation as well, by means of procedural rules adapted to the specific needs of the sports world. CAS was established because ordinary courts were ill-suited to deal with the unique needs of sport. International sport requires neutrality, specialist expertise, consistency of outcomes, and above all, speed, which domestic courts in different jurisdictions could not reliably provide. Today, CAS is designated as a final appellate body by most international sports federations and the International Olympic Committee, IOC. Its decisions are binding and enforceable worldwide, subject only to a very limited review with the Swiss Federal Tribunal under the Swiss Private International Law Act, which Paul mentioned earlier. If there is a violation of fundamental rights, CAS decision, or the Swiss Federal Tribunal ruling, a party may apply to the European Court of Human Rights. That is the final appeal process, so to speak. Over time, CAS has developed a coherent body of sports jurisprudence known as Lex Sportiva. So that's how the wider, broader ambit how CAS operates.
Thanks, Dato'. Thomas, if I can just bring you to one of the things that Dato' said that CAS does is resolving dispute through mediation. Do you see room for the use of mediation in the context of sports-related disputes?
Let's first have a look at what mediation is, and I won't. It's a definition that I will put forward. It's by no means academic, so please, no complaints afterwards. It's a voluntary process by which two parties usually can be more seek to reach a resolution to their dispute, and in doing so, they're held by a mediator who's an independent, impartial person who will be seeking to help them. So within sport disputes, we have various mechanisms that look kind of like mediation. We have the ability to settle cases by having the parties agreeing on an outcome, but that's not exactly mediation. Why? Because yes, the athlete is there, but the other party is typically the international federation or the sports body that will be seeking to apply a sanction on the athlete. If there's no agreement through this discussion, well, there will be a disciplinary process before hearing panels. So we're not really talking about mediation. A place, however, where we have something that is a bit more similar is in relation to governance-related disputes, especially amongst member associations. So I alluded to these disputes earlier. Imagine in a country you have elections taking place, or you have government interference. So you have two bodies that claim that they were properly elected. They may disagree on what is to follow. So we actually have quite a lot of these cases. And the solution we have been putting forward is putting in place a working group, which is a form of mediation, where the BRF will act as an independent third party whose role is not to decide on the way forward, but to help the parties identify their interests and try to help them find agreement on the process, on the content, in this example of the Constitution, and on what follows. So usually for us, it will be elections. So we do set the arrival line, but we will try to help the parties decide on the process and on the means on getting there. It's not exactly mediation, or it's not 100% pure definition of mediation, because if they cannot find an agreement, then we have other tools, and that removes the voluntary aspect of mediation, but it's getting quite close. And we have used it, and it has proved to be quite successful, as we have been able to lift some suspensions we had by having everyone generally happy about the outcome.
What would you call such a model? A hybrid model, mediation, and
well, to avoid disputes with the academics who may question us that it's not that may question the word mediation, we just call it a dispute resolution model. And in our rules, we haven't, actually, it's an interesting follow-up question. We haven't defined it with a lot of requirements or details. We want to keep the flexibility in deciding what kind of model working group will work best based on the circumstances of the country. We have 204 members. They all have their own national law. Every dispute is different. So we weren't too prescriptive in our approach, but we opened the door to this possibility because the principle of autonomy of sport is actually quite a paramount principle. And we do protect our members against interference, including from ourselves. So we try to keep it minimal at the same time.
I can just ask a follow-up. Out of 100, let's say, how many cases you can successfully resolve with your mediation kind of, hybrid model that you're talking about?
In the context of governance-related dispute, well, first, fortunately, we don't have hundreds of governance-related disputes.
But I thought, let's go with 100.
Usually, we need to be patient, and a dispute needs to ventilate itself. The parties need to feel heard, and eventually, when we see that it's going nowhere, then is the time to suggest this kind of process. As of now, we have one process that had been settled, and it's quite something we've been doing for the last year or so. One member association has its problem solved through this kind of process. We are working with another one. And so I would say 2 out of 3, we're going for this approach, but in some other cases, the circumstances make it very difficult to find an agreement.
Thanks, Thomas. Moving on to Paul. Paul, from your vast experience, how should the encouragement of settlement be approached in integrity-related cases, and where do the potential risks lie?
I disagree with the proposition. I wouldn't be encouraging anyone to settle an integrity case at all. I think that nothing short of a scorched earth policy towards cheats should be pursued, because cheating is at the very heart of sport. At the end of the day, this is not like a civil case where there's a deal or a bargain, where you can always try and settle a case and come up with a mutually acceptable commercial outcome, or a matter dealing with money. Regulators are there to regulate, and rules are there to be enforced and applied. And rules, when they are consistently enforced and applied, have the happy consequence of general deterrence, especially in integrity matters. Now, while I can understand the motivation in terms of saving costs, in terms of coming up with what Thomas described as I think it was a dispute resolution model, I'm yet to find any sporting dispute where the outcome reached, even where the athlete is successful, or where there is a case resolution agreement, to use Thomas's words, where everyone is happy. Nobody is ever happy in a sporting dispute. They might accept the outcome, but they're never happy. The association is never happy because it's costing them money, which they could be spending on sport. The athlete's never happy because they're looking at a suspension and it's costing them money, and also reputationally it's affecting them, reputationally affecting the sport. So in a sporting context, I think sports organisations should regulate, not mediate. And a really good illustration of the problem with this is found in article, I think it's 10.8.2 from recollection of the World Anti-Doping Code that deals with the case resolution agreement. Now, one of the real aims of the wider code was for there to be a harmonisation of outcomes so that you have consistent outcomes for doping across sports and across different regions. And the difficulty with the case resolution agreement procedure under the wider code is it doesn't emit the same transparency of process that a published arbitral award of CAS does. Now remember, with CAS, unlike other international commercial arbitral institutions, in most instances, not all, but in most instances, while the procedure within CAS is private, and I use that word deliberately, rather than confidential, while it's private, the award in most instances is made public. So what we have in sports arbitration, which is a good thing, is we have a series of published awards where we can see certain outcomes and we can see a jurisprudence, a lex specialis, a jus laudorum, the law of games, develop, where we can see how these cases and these regulations are applied with a view towards getting more consistent outcomes. And the problem with case resolution agreements is there's not that transparency in the process of reaching an outcome which is acceptable to the athlete, the national federation and wider, because it's usually all done by letters, or a case conference between the parties. And it's simply just an announcement. The anti-doping rule violation has been met with a sanction due to a case resolution agreement of X so many months. And a really good example of that, and this is not commenting on Peter Sinner or on the merits of the Sinner case, but it's a really good example where a lot of people in the general public say, why did Peter Sinner, they start comparing Peter Sinner's case to another athlete that might have been given 2 years or 4 years or 18 months. Why did Peter Sinner get off so lightly? You hear that. And what you don't get to see, there probably was very good reason for Peter Sinner to get the light touch, the relatively light touch he did compared to other people who offend doping regulations. But you're never going to see the detail of that or the reasoning behind it in the way in which you'd see it in a CAS award. And to me, I think that's a flaw in the process that I don't see it going away, because doping cases cost money to run. Nowadays, when you're in CAS, everyone's pretty well represented either by a counsel appearing pro bono for the athlete or wider and national federations being spending money on good legal representation. So anything to try and lessen that financial burden is probably a good thing, but what you're doing is you're impacting on the qualitative considerations of sport and justice, where you don't have that transparency and it runs the risk of producing inconsistent outcomes. So I say national federations and international federations don't mediate, regulate. And especially for sports integrity, because it strikes at the very heart of what sport is, where we see it as being a fair and genuine contest. That should be enforced harshly. And well, I say harshly, it should be enforced strictly, not harshly, but strictly. And if there are harsh penalties for it, then I think personally that's a good thing.
If I can just ask any of you, if you can answer, then what type of sports-related cases or disputes can be mediated? What would you?
I'd say fights between sponsorship arrangements, anything of a commercial nature, but anything of a participatory nature, disciplinary nature, probably not. I mean, if it's a fight between a high-level international athlete and the National Swimming Federation over independent sponsorship, whether your sponsor clashes with the National Federation sponsor, then that's a commercial dispute, as far as I'm concerned. It's not a pure sporting dispute. It's not dealing with doping, selection. And a good way to test this is, how do you settle a selection dispute? Nobody's going to, no sports federation going to say, we got it wrong, okay, we'll pick you and knock the other person. It's just not going to happen. And so anything to do with selection, conduct, integrity, doping, governance, gender, sex and gender, which is the new area, that just has to be regulated. Anything to do with money, by all means, mediate if you can.
Thank you. Dr. Raja, now bringing the discussion back to Malaysia, given your experience serving as a sports dispute committee, SDC, could you explain the role of SDC under Sports Development Act and how it operates and how it differs from arbitration at CAS?
Yeah, the Sports Dispute Committee is a creature of statute. As you said, the Act was established under the Sports Development Act of 1997. The members of the committee are appointed by the Minister of Youth and Sports. SDC shall have the responsibility to hear and resolve disputes referred to it by any member of a sports body or the sports body itself. The SDC shall ensure that sports bodies and other parties to a sports dispute, including athletes, are given an affordable, just and speedy means of resolving a sports dispute. The Act further provides that every sports body shall resolve any dispute arising from its members or with its committee or governing body in accordance with internal procedures prescribed in the regulations. So this is the same principle I mentioned earlier. You got to exhaust your domestic remedies first. Its role is to resolve disputes that cannot be settled through the internal mechanism of sports bodies. The SDC typically hears disputes involving members and sports associations, disputes between sports bodies, the governance or disciplinary issues within Malaysian sport. We have the power, the SDC, to conduct hearings, and which we have conducted, and make determinations that it considers just and proper. The key distinction to my mind between the SDC and CAS lies in their nature and legal foundation. The SDC is a statutory dispute resolution body with a final appeal to the minister, whereas CAS is an international arbitral tribunal grounded in contract. Together, they reflect how sports disputes in Malaysia are resolved through both domestic statutory processes and international arbitration frameworks. That's how the key differences are.
Are there a lot of cases that we get in, there's a committee, have a lot of cases to deal with?
Yes. We have cases, of course, it's confidential nature. I myself had chaired at least 1-2 of the SDC cases. There are a few pending. And it's a committee of 3 at any one time. And the hearings are always held at most convenient place will be at Bukit Jalil.
How many do you have in your committee then?
How many? Sorry?
How many members are there in this committee?
In total, there are 5 of us. Under the Act, the minister can only appoint 5. At any one time, anyone sitting, there's a member of 3 of us. But the minister has, the former minister actually, she has included out of the 5, 2 are ex-athletes. 3 are lawyers, 2 are ex-athletes. She wanted to bring in the sports dimension in as well from the athlete's perspective.
Yeah, that would have been good. Yeah. Thank you, Dato, for your explanation. Now, Thomas, moving on to you. What are the hardest judgment calls for International Federation faces when resolving disputes internally? What are your challenges?
We have various challenges, and I think one was introduced by myself and completed by Paul in his subsequent intervention. So there's a question of what to do with the case. Should we go to a hearing panel or should we try to settle? And I think Paul explained very well the reasons against settling a case. It doesn't generate jurisprudence for our sport or for the wider sporting community. There's a risk of improper perceptions. We spoke about the Yannick Sinha case where it sounded like there was a discussion in a dark room and they found an agreement without much reasons, and that was the outcome of the case. So that is quite problematic. Also, we cannot, we have as practitioners our own opinions about a case, and naturally we want to test our judgment, test our investigation to see if a hearing panel would agree with us by settling a case that does not happen. Now, there are various practical considerations why we would settle a case, and I think you will all be familiar with that, efficiency and so on. And you can agree or disagree with them. I do get that. Maybe one point that I think is interesting when it comes to settlement is that we have various mechanisms to ensure that there's some form of third-party verification of the settlement outcomes. So under the World Anti-Doping Code, you have WADA for Article 10.8.2 that will need to weigh in and provide its agreement with the settlement agreed to by the athlete and the International Federation or the National Anti-Doping Body. Is it perfect? No, because it still provides, there's still a potential lack of clarity in relation to the reasons for that settlement. Within the Badminton World Federation, we have a special role. It's called the referral officer. The referral officer is an independent sports lawyer to who we can ask to endorse the outcome of cases, whether it's a decision to settle, whether it's a decision not to proceed with a case following an investigation, and that provides a form of control to the decisions made by the BIF Secretariat. So even though it's imperfect, we try to provide this third-party verification mechanism. More generally, I wanted to get back to this topic. What can be a challenge for the BIF is make sure that we deal with everyone, regardless of their level or their position, in the same way. I think in Malaysia, there was a famous case that was about which a lot of ink was spilled, the case of Lee Chong-wei a long time ago, and that's before my time. Do we deal with the Lee Chong-wei the same way as we deal with a national athlete from a non-badminton nation? Well, that's a relevant question. Or what happens if an official is caught in a potential breach of our rules? In the past, we would have our council member deal with these cases. And we all know how difficult it is to decide on a case that involves someone that we know. That's why we moved in the direction of having independently appointed arbitrators to make sure that there is no bias or no appearance of bias. But it's still something we are working on, something imperfect. But as we go along, we identify these weaknesses and we get as a private organization to improve gradually.
There are some safeguards in place.
Correct.
Paul, from your experience sitting as an independent arbitrator in complex sports disputes, what are the most difficult issues tribunals face when balancing regulatory objectives with fairness to athletes and stakeholders?
There's no difficulty.
No.
You simply decide the facts and dispassionately apply the regulations to the facts, having regard to decided cases to ensure you get consistent and fair outcomes. No difficulty.
From an arbitrator's perspective then, where do disputes most often arise in relation to sanctions, and how should proportionality be assessed in sports cases?
Well, again, it comes back to sanctions are always going to be confronting when an athlete is facing a sanction, but if the facts make out the allegation, and then obviously submissions are made in mitigation, and they're obviously taken into account, and so you just go through the process, and the sanction will be what it will be. This is really I'd like to think of myself as a black letter lawyer, and I've applied some pretty harsh sanctions in the past, but having done that, it's something you do dispassionately. It's obviously there's a person involved in this, and you listen to their submissions carefully and take on board what's submitted by their counsel, but your role is to dispassionately do justice and decide the case. And so you can't let your personal feelings interfere with that process in terms of what might ultimately inform the right outcome. If you stick to that dispassionate black letter approach, you're always going to get an outcome which is going to be consistent, and that of itself will be fair. So consistency and transparency are the keys, and that's one of the really good things about sports arbitration system in CAS and what is happening in terms of regional or national sports tribunals as well, where decisions are published so that you get to develop, firstly, transparency, that ensures fairness, and secondly, consistency of outcome.
There's precedence there. Before we open up to questions, there's one last question for our panelists. Dr. Raja, looking ahead, what steps do you think are necessary to strengthen Malaysian sports dispute resolution framework, particularly in terms of independence, capacity building, and alignment with international best practice?
Looking ahead, the way forward in resolving sports-related disputes lies in professionalizing dispute resolution while respecting the unique realities of sport. This means strengthening internal governance within sports bodies, ensuring clear constitutions and fair procedures, and encouraging early resolution through mediation and specialist tribunals rather than defaulting to litigation. At the domestic level, Malaysia's statutory framework through the Sports Dispute Committee provides accessibility and structure, but it must operate alongside credible internal mechanisms and specialist arbitration. At the regional and international level, arbitration, whether through ad hoc panels at major games or institutions like CAS, remains essential for delivering speed, consistency, and neutrality. Ultimately, the objective is not simply to decide disputes, but to protect athletes, preserve the integrity of the competition, and maintain public confidence in sports. The way forward is therefore a balanced system, one that combines good governance, specialist education, and respect for due process, so that disputes are resolved fairly, efficiently, and in a manner that allows sport itself to thrive without compromising the integrity of the sports. Thank you.
Thanks, Dato'. And Paul, from your perspective, how do you see international sports arbitration evolving over the next decade, and what reforms or shifts are most critical to maintain confidence in the system?
There are three things. Firstly, CAS need to appoint and ensure they continue to appoint experienced sports arbitrators on sports panels. That there will be sports arbitrators all around the world, but if it falls down, if it goes down that rabbit hole of appointing people who are not appropriately qualified just to tick a diversity and inclusion box, then ultimately it's going to be to the detriment of CAS. Now, having said that, it's also, I believe, important on CAS and the International Olympic Committee and international sport to ensure that people who don't have the access to sports law education that those in the West or in Southeast Asia have those opportunities to be properly educated so that you can have a diverse range of appropriately qualified arbitrators. That's obviously the idealistic view of how it should work. The idealistic view of sport is that it should also take place on a level playing field. But we all know sport has never taken place on a level playing field when you look at athlete pathways, development opportunities for, some countries, rich countries just do better. They have more money to spend on facilities, coaching, population tends to have better standards of living, better nutrition, better medical care. So this myth that international sport takes place on a level playing field is just that. So that's the first thing. The second thing is that CAS is evolving into what I see as being an appellate tribunal. It's become a victim of its own success in many ways because it's become very expensive to conduct cases in CAS, whether you're an athlete or whether you're an international federation. Cases of themselves, given the way that sporting regulation is now much more complex. Once upon a time, when I first signed an Olympic shadow team agreement, it was like 50 or 60 pages in length. Now, with all of the different policies and everything that are incorporated by reference, it's almost 300 pages in length. So sporting regulation of itself has become more complex, which means disputes are more complex, which means they're more expensive to run. So the difficulty with that is then while CAS has evolved into a specialist appellate tribunal, where's the specialisation going to be to determine these cases at first instance? It's going to be in regional arbitral tribunals, hence the need for regional arbitral tribunals to develop again an expertise of lawyers who can develop that specialised knowledge of sports law to be able to fairly adjudicate those disputes, which was the objective of the Asian Sports Tribunal. I don't know how that's going at the moment, but that was certainly the objective many years ago when I devised the idea with Datuk Sundaraju and also Tunku Imran. As to where that will go, we'll see, but certainly that was the idea. And the third thing where I see sporting disputes evolving is with more and more money now being involved in sport. I think there's going to be a lot more emphasis now on commercial sporting disputes, fights between broadcasters and event hosts. A really good example of that was the CAS arbitration, which settled, where I acted for the Commonwealth Games Federation against the state of Victoria, which resulted in a £200 million settlement payable by the state of Victoria to the Commonwealth Games Federation over the Victorian government and Australia's decision to pull out of the 2026 Commonwealth Games. So sporting events generate huge amounts of money, and as a result of that, there's more at stake in these sporting disputes. And you just look at the money being generated with Formula One at the moment, and where there's that type of money involved and the ripple effect for sponsors and broadcasters and the like, I see that as the new killing fields where sports arbitration is going to, the commercial side of sports arbitration is going to take on a new life in the years ahead. So those three things are where I see it all happen.
Thanks, Paul. Thomas, last questions to you. How do you see sports tribunal dispute resolution evolving over the next decade at the international federation level?
I think a theme that is still quite fluid amongst international federations is the topic of integrity units. And maybe that's a step right before dispute resolution, but I think nevertheless quite an important step. In the past few years, you've seen several international federations create their own integrity units. And the reason for that is that they want to avoid conflicts of interest. Imagine you're an international federation, you discover that your top star is involved in a doping offense. Well, you won't be exactly keen to prosecute that athlete normally. And so there might be a perception of conflict of interest in those cases. And that is why these international federations will delegate the integrity function to an external integrity unit. Now you have some international federations that have adopted a fully independent, operationally legally independent model. I can think of tennis and athletics, but you have a whole spectrum of independence levels based on the international federation. And thinking of BDF, for example, our integrity unit is internal. It's a department of the organization. So how will we find the sweet spot between full independence, for which we may not exactly have a need due to the number of cases that we have, and the other end of the spectrum where right now, well, there could be potential biases or perceived biases in the activities of our integrity unit. So that's the first part. Then I thought what my fellow speakers were talking about was quite interesting. It's about keeping the arbitrators in our disciplinary panel competent, I mean, from a knowledge perspective. So a problem we used to have at BWF was that we had our tribunals, our disciplinary panels, and each of our 5 continental confederations had their own disciplinary panels. We don't have such a big caseload that justifies so many arbitrators. So we decided to pool our resources together and have one BWF independent hearing panel that hears all cases through the badminton community. That works at world level, at continental level. So we're looking at how could that evolve in the future? Could it also help at national level if there are disputes? Because we have arbitrators with a proper caseload who are familiar with badminton rules. So as an international federation, this is the kind of questions we are looking at because we want to make sure that our community is properly serviced also from a tribunal perspective.
Thank you so much to all of you for answering all the questions brilliantly. We have a couple of questions online. Says question to Mr. Paul or other speakers are free to answer also. Following the Manchester City FC against UEFA CAS decision, was this more on legal technicalities or substantive innocence? What does this case say about the effectiveness of the financial fair play or rules?
Is that for me?
Yeah, it says to you or anyone who can answer.
I think our erstwhile interlocutor, the question, I'd be interested in their view on it. They can download the case on the CAS website, read it, and they can tell me. In a nutshell, the reasons will reveal what I think the case was determined quite properly on its merits by an experienced arbitral panel. Ultimately, back in 2000 or 2021, I think it was, didn't City have their fine reduced from 30 million to about 10 million euro or something like that over a fine about allegedly concealing sponsorship, I think, from the Middle East. Thinking behind that, of course, and it's been an ongoing fight since then with the Premier League, which I think resolved late last year, where Manchester City ultimately, we don't know much about the settlement because it's confidential, but they ultimately accepted they had to play by the Premier League's financial regulation rules, which thinking behind that, of course, is it's in the interest of the game for none of the big clubs to get into financial difficulty, because then that causes problems for competition as a whole with broadcasting and sponsorship arrangements. So it's in the collective interest of all of the clubs playing in the Premier League to ensure that all of those clubs are financially viable. That's why there are regulations ensuring that go towards ensuring the financial viability of the Premier League clubs, which of itself requires some degree of transparency. So ultimately, this comes back to what we were talking about before. It's a commercial deal. There was a mediation done. It's business. You don't have the same transparency you'd otherwise have if it was a conduct sporting dispute. Although what you do have is some transparency given the dispute with UEFA before the Premier League dispute was originally determined in CAS, and what you have there. And I haven't read the case for a long time, so I can't really comment on it. But my impression is that there's no legal technicality, but from Manchester City, they just well represented. They got a good outcome, and the case was determined on its merits. And you see now where they are, because the dispute that evolved into a similar dispute with the Premier League. They accept that they're bound by the regulations, but we don't know whether they've had to pay money back or what they've had to do. So we just don't know.
Thanks, Paul. I hope that answers questions. Thomas has a question for you as well. In Sun Yang and FINA, this case turned heavily on procedural flaws rather than substance. From your experience, how critical do you think that procedures need to be clear and perfected in order to preserve the legitimacy of anti-doping decisions?
Thank you for putting me on the spot. I'll confess that the decision in the case of Sun Yang is a bit distant in my mind, but perhaps I can explain some general principles in relation to anti-doping and anti-doping procedure. So in the code, in the international standards, which act as secondary documents to the code, there's a lot of requirements for the anti-doping process to take place. Certain steps must be followed. There's a lot of formality. But in the real world, things can be a lot messier. And it may be that the doping control officer, when filling the form, will skip a box and so on. So those are called departures from the international standards and basically departures from procedure. Now, how it works in the codes, a departure from the international standards will not automatically make the doping control or the test outcome invalid. The athlete will, of course, need to show that there was a departure from international standards, but then there will also be a need to show that this departure led to, or reasonably could have led to, the positive result outcome. So, for example, if there's a spelling mistake to the name of an athlete, but otherwise everything in the form is correct, including their identification number, well, there's no reason to believe that despite the incorrect name or the spelling mistake, the test outcome was incorrect. And in the Sun Yang case, that was the gist of the dispute, where they looked at the various departures from the international standards and if they could have reasonably led to the AEF, to the adverse analytical finding in the case. In relation to, well, I will skip the second question because I feel that Samrit may want to delegate it to someone else.
Yeah, I will just go to the next question because the second question is sort of related. Can we answer? We are seeing the emergence of institutional arbitration rules specifically tailored for sports disputes. In your view, why is there a need for a separate set of rules, and what are the key differences compared to conventional arbitration framework? Dato', would you want to take that question?
I can briefly answer that because sports by nature, each association has their own set of rules. I mean, it's very pyramidal, right? So the laws applicable to each of the countries are what will be completely different. So to have one standardized international rules applicable to hundreds of countries with so many different types of sports, I think it's really not physically viable, but without compromising the autonomy of sports. That principle runs throughout in the sports arbitration. That's how I feel at this stage.
Anyone wants to add? We have actually run out of time. Michelle, are we?
Yeah, we can wrap this up if you have nothing to add.
And any of you got anything else to add on? Paul, Thomas?
I have nothing to add.
Okay. Thomas, anything from?
Nothing specific to add, but I just answered our friend Samuel in case he wants to look at the rules on departures from international standards in the World Anti-Doping Code, in case that's of interest to anyone.
And also, Samuel might also want to have a look at the Swiss Federal Tribunal decision to set aside the first 8-year ban, when there was a departure from the international standards that Thomas talks about because of a rather regrettable circumstance of bias on that panel. And then what happened was on the second Sun Yang hearing, it resulted in a 4-year suspension. So, as well as having a look at Article 3.2.2, Thomas makes a good point. The departure from international standards was an important part of the case, but from an arbitration point of view, the bias issue is pretty important. So you need to have a look at both Sun Yang cases on the CAS website and the Sun Yang decision of the Swiss Federal Tribunal that set aside the first CAS award, which is harks back and completes the circle of what I referred to earlier in the challenging CAS award. You'll have to do so in Switzerland. Needless to say, Sun Yang would have been very much buoyed or supported by the largesse of the Chinese government, would have supported and accommodated that financially for that to take place. So no inequality of arms there. And that effectively makes my point that that's almost what's needed to have the state resources behind you, or very significant resources behind you in your quest for sport and justice, if that's what you need to do to challenge the award in the highest court in Switzerland.
Thank you so much, Paul. I will say thank you again to all of you, Paul, Dato, Raja, and Thomas, for being, for and giving us such an enlightening discussion here. With that, I thank you all the participants for watching, and I will let Michelle handle it from now.
Thank you.
Okay, thank you,
Thank you,
Professor
Sarah.
Samrith. And yeah, thank you very much to the speakers for their very insightful discussion. And for our very next BicTok session, BicTok 40th session, will be held on the 18th of March 2026 on the topic of principal tort-related claims in the construction industry. So do keep an eye out on our social media pages and our website for updates on this session. And we look forward to seeing you then. Thank you and have a pleasant evening, everyone.